Good evening and welcome to season 2 of Addressing the Issues. I'm so excited. I don't know if you've been following, but I have, and it's been upsetting me. The discourse that's happening right now, not only at question period, but in specific committees, and people being brought in and pretty much abused, pretty much bullied, pretty much anything negative that you can figure out. And just recently, about last year, a citizen brought before the House of Commons to be admonished for the Arrive scandal. To me, this upset me because we're not living in the 1950s McCarthy's and we're not living in the 1930s Stalin time. So I said, how could this be possible? So my two guests with me today are constitutional lawyers, or lawyers in the sense that they understand this topic and have written an article about it. And I am introducing them right now here and joining the show. So first of all, Alyssa Holland is a partner at Conway Litigation in Ottawa. She's a former deputy law clerk to the Legislative Assembly of Northwest Territories. She practices law across Canada, including in the Northwest Territories and Nunavut. And she's appeared before multiple courts across this country, including the Supreme Court of Canada. She also advises parliamentarians on a range of legal issues, including parliamentary privilege and ethical matters. Welcome, Alyssa.
Thank you.
And with you, your colleague is Marion Sandilands, a partner also at Conway Litigation in Ottawa. She's appeared before multiple courts, including the Supreme Court of Canada. She teaches constitutional law at the University of Ottawa. She speaks and publishes on matters of constitutional, public, and administrative law. She has provided expert comments on constitutional issues for national media, including Toronto Star and Global News. She has helped prepare clients to appear at House of Commons and at Senate committees. Welcome, Marion.
Thanks, Andy. Great to be here.
All right, so this is an exciting topic for me. For those of us joining in the ether here in Brantford, we have our local MP, Larry Brock, who is very active in the committees. So a lot of people with bated breath will want to hear what we think about what's going on in Ottawa. So with that said, let's get straight to it. We've seen public servants and private individuals questioned rather aggressively by parliamentary committees. These proceedings can be very adversarial, very even hostile. How is it that a committee of parliament can do this?
That's a great question, Andy. And to answer it, there are a few key concepts that need to be understood, but I really don't think are very widely known. So the first is that in Canada, Parliament is totally independent from the executive, or what's commonly called the government, and the courts. This dates back to at least the 1600s in England, where our parliamentary system comes from. And it was really, created in conflict between those two different branches of government, primarily the executive, the king, and parliamentarians. And this is really baked into our system of government, this independence. It's what allows Parliament to do its job of holding the executive to account, to be independent in debating the laws that it's going to pass, and for it to ask hard questions about matters of importance to our country. So that's the purpose of this independence that it has. To protect this independence, Parliament and all of our provincial and territorial legislatures benefit from something called parliamentary privilege. It's one of the oldest rights in our legal system, and to be honest, I think it's one of the least understood as well. The basic idea behind parliamentary privilege is that members have the power, a number of powers that enable them to do their job. So one of those powers is freedom of speech. That's the idea that they have to be able to speak truth to power to hold the government to account. Parliamentary privilege also gives Parliament and other legislatures certain fact-finding tools. And so those include the ability to require witnesses to appear before committees. Those witnesses could be from government, they could be ministers, or they could be regular private citizens. And committees that would ask them to appear are really just smaller groups of MPs from different parties that have been tasked with studying a certain topic. Could be national defense, could be foreign affairs, you name it. There's a whole range of committees. Parliament can also require people, including private citizens or corporations, to produce documents for the purpose of Parliament's work. So this is actually a very long-standing power that Parliament has had. It's foundational and it dates back hundreds of years. But what I think isn't widely understood about this is that only Parliament gets to decide how it's going to use these powers. So the courts can't get involved. And the normal legal rules that govern, demands for documents, we have a whole legal regime around that, questioning of witnesses, none of that stuff applies when it's Parliament that's requesting it under parliamentary privilege. That doesn't mean that there can't be any rules that might bring more civility or what we call procedural fairness to these processes, like committee meetings. But what it means is that it's up to Parliament to decide if it wants that in place, and if so, what it would look like. In practice, what that means is that we don't have those in place right now. So parliamentarians now can question a witness without any real limitations on either the tone or the content of that questioning. The real limits are more political than legal, and that has consequences, right? So that can shape which witnesses are called to appear before certain committees, and the kinds of questions that they're asked. And really, that's fundamentally shaped by the political agendas of the parties that are represented on those committees. I think I can say that in a very divisive political climate, like the one we're in right now, where an election is likely imminent, the style of questioning can thus become a lot more aggressive, as you said. And questions can sometimes seem to be more about showcasing a certain member of Parliament's political views rather than actually getting an answer from the witness. Those are those political constraints we can see operating in the absence of any legal constraints.
So you open up an interesting concept. So and again, remember, we're creatures of habit. We're watching CPAC, we're watching election, we're watching question period stuff on our YouTube. And one of the things that upsets me is how these perceptions. So here I am, we're in a committee, I'm watching Tom Clark, I'm watching somebody else. And I'm not going to say which party's members. Somebody says, I have a question for the witness. They ask this question in a grandstanding, and within 2 syllables of the witness answering, they say, no, it's my time. Now, if this was Law and Order or any other show, there would be a lawyer saying objection, and there would be a judge that says sustained, and he says, careful, Mr. So-and-so or Miss So-and-so, you're skating on thin ice. But evidently it's not happening. And what I see is like this miscarriage of justice. It's like the person is being villainized and their reputation is getting hurt, and nobody is stopping the parliamentarian from doing that. So are there rules governing, committee power to question witnesses and how they treat them? And then the next question after that is, if there are, how does that compare to court of law?
Andy, I'll try
I'll
try to break it down for you, because I think the comparison is really interesting between a court of law and a committee. So let's think about it. So let's think about how a court is set up. There's lawyers and there's judges and there's witnesses. And how is it framed? Well, it's adversarial. It's one side against the other, or in a criminal case, the accused against the state. And there are rules that govern that whole process. There's rules of admissibility, rules about privilege, rules of what witnesses can or cannot speak to. All of that is governed by a body of law. How does it work in a parliamentary committee? It's a different set of rules that govern, right? How is it set up? You have the chair of the committee and you have the members of the committee, who are all members of the legislature. And there aren't really 2 sides like a court. There may be different sides. Maybe everyone's on the same side. Maybe there's a multiplicity of perspectives and agendas going on. So it's all more multi faceted. And what are the ground rules? Well, they don't have that body of law about admissibility like you have in a court. So as Alyssa was saying, a committee has unrestricted power to ask questions and get documents. So how does that play out in the way the questioning works? Well, in a court, you have lawyers from each side who will take turns asking the witness questions. And there are rules about how they can ask questions, what kind of questions they can ask. There's rules of evidence. Something can't be admissible if it's hearsay, or it's not relevant, or it's speculative, all kinds of rules, protections against self-incrimination. And as you mentioned, one lawyer can object to the questions. And then if a lawyer objects, then the judge will rule on, is that question proper or not? And at the end of it, there's a final ruling that comes out. There's a decision or a verdict. So that's how a court is set up. How is a committee set up? As you mentioned, you're exactly right. Each member of the committee has a certain amount of time. That's the rule. So they have 5 minutes or something, and they can do pretty much whatever they want within that 5 minutes. It goes around the table. So, you have your 5 minutes, you can ask a question, you can talk for the entire 5 minutes, you can get the witness to talk, you can ask 5 questions or 1 question. And once your time is up, the chair will say your time is up and it goes to the next questioner. That's the rule that governs, because that's the rule that Parliament has set for itself. In terms of rules of evidence, not really. They don't have those kinds of rules the way a court does. And objections, there's nobody there to object to a question. Another member can't stop a member from asking a question. So there's nobody there to stand up and object to a question. And in terms of a dispute, well, the chair of the committee is in charge of the procedure, but they don't usually intervene unless either the member's out of time or the member's being really improper and badgering a witness, for example, or being really rude. The chair will sometimes intervene and stop that from happening, but sometimes they won't. And in terms of the outcome, sometimes the committee will issue a report, but sometimes they don't. Sometimes they just move on to another topic. So there's no kind of verdict at the end of the day, a finding or vindication or a condemnation. It just kind of, the evidence goes there on the public record, and sometimes it just lives there.
All right, so let's stay on this before we move on, because it's interesting, because for people who tune in, they want to see civility. They want to see no miscarriages of justice. And I understand this better now, that, that would explain why they say, I have a, this is my time, whatever it is. And you would think that it was just more narcissistic, that they're saying, this is my time, hey, look at me, type of thing. But again, I think this is very weird. If you're going to summon somebody and chastise them or question them or impugn something upon them, you need to have, in my opinion, and I'm just a layperson here, but you need to have the substance to ask the question, and you need to allow the question to be answered. So what I'm noticing in what Marion, what you said, is that in where there is no lawyer, there are other members of Parliament, usually we call them the other side, who is like, point of order or whatever, and then stops the proceedings, and then the chair usually doesn't support the point of order, and then there's snide comments that come from the accusing side, and then it just becomes a name calling thing and whatever, and then everything gets like mitigated, and people just sit there saying, why am I tuning into this when I could be doing something different with my life? So listen, before we move on to a specific question over committees, is what are we seeing here? I see members of Parliament squaring off against each other. They're squaring off against the witness. The one side attacks, the other side defends, and the defending side is always, I'm so sorry this is happening to you. I'm so sorry that you're undergoing this. This is not fair, and I'm just saying, then just don't do it. So let's see how can you make it easier for us lay people watching the show, understanding this, to see like why is this happening?
Well, I think it goes with what you said at the beginning of that question. I'm not sure I agree with you that everyone actually wants to see civility. And I think certain members who are being more aggressive in their questioning, or perhaps using a question as an opportunity to make elaborate statements of their own views, their best guess is that people actually want to see something else. They either want conflict, or they want to see them aggressively maybe holding the government to account, or whatever it is that the committee is dealing with. And so because the constraints that really apply here are political and not legal, each member is making their own decision about what those constraints mean, what they can most usefully do with that committee time. And so as you say, you'll often see, a real hard-hitting cross-examination for one member's time, followed by another party who has the opportunity to speak. And it's all softball questions, trying to make the witness look much better, maybe to address some of the damage done. And that really reflects the different political calculuses that each member and each party is bringing to the table.
All right.
All right. If I could just add to that, Andy, one other thing it might be important to know about committees and how they work is that not all members of the committee necessarily want the committee to be doing what it's doing. They don't necessarily want this witness here. They don't want necessarily this witness to be chastised. It's other members of the committee that are pushing for this. So you often see there's tension between members of the committee on what the committee should even be doing. Sometimes that plays out right in front of the witness.
Okay, and that makes perfect sense. We've seen this on the spectrum. We've seen this with the SDTC. We've seen this with Tom Clark, and we've seen it in the middle with foreign interference. And all good topics, but which one is more heinous, like a $9 million condo being bought or foreign intelligence, subverting our democracy. I would go with the foreign interference rather than the condo purchase. Okay, so I'm going to throw this to both of you. Let's look at it. We're doing fantastic here. What can, in your opinion, because we've tackled this now. Now we're drilling down to the committee level. So what can a committee or the House of Commons do broadly to enforce its powers? We'll give the example of the article you wrote. They really wanted to see Mr. Firth, and they've submitted some sort of request at the Sergeant of Arms to bring him, with lock, stock, and barrel to the Parliament, so he must be admonished. I think that's a very medieval, and I think that's no place in a democratic society like this. Don't want to liken it to the secret police coming for you at the middle of the night, but it's scary that it says. So what can a committee or the House of Commons do to enforce its powers? I don't think it has its own police force to do it. So anybody want to start?
So medieval is a really useful word to use here, because this brings us back to the point I was making at the beginning about the origins of parliamentary privilege, right? So we have this totally unfettered power that doesn't have the checks of, the Charter of Rights and Freedoms and other legal doctrines that have developed. None of that applies to how Parliament and its committees exercise its privileges. The flip side of that is that we have these extremely powerful enforcement tools, but they're really like bludgeons. They're so powerful that they're actually rarely used. So if someone doesn't comply with an order, there are a couple of tools that the House of Commons or a legislative assembly can use. The first is, and this goes back to the example you gave of Christian Firth, being what's called to the bar. Called to the bar, that's not a term most people will be familiar with. There's actually a physical bar in the House of Commons and in other assemblies that separates the area that's sort of members only for the members of that assembly from where everyone else is allowed to go. So the person who is called to the bar is summoned there to be admonished or reprimanded or to answer questions, and really to submit to the authority of the House. So it's highly symbolic. It is rarely done, particularly for private individuals, private citizens. And the idea is that if you've offended the authority or the dignity of the House, you will be called to account for that behavior. So that's option one, largely symbolic, but can have significant reputational impact. It's often reported widely in the media when it has happened, certainly in recent years. The other option, and this is the only other option with respect to a third party, so someone who's not a member, is that you can be detained or imprisoned. And so that's more of a theoretical option. It hasn't actually been exercised in Canada since 1913. And when it last was, that was actually because an individual refused to answer questions, and they were imprisoned for about 4 months until the parliamentary session ended. There's a real question as to whether Parliament actually could do that again. I mean, we have historical precedent, but it's pretty old. And I have a hard time seeing the House of Commons actually doing that. And so those are the two tools. They're, as I said, extremely blunt, which is why they're rarely used. And I think it's important to contrast that to what happens if you disobey a court order, for example. There are many other tools that a court can use to enforce its orders. It can fine you. There's lots of ways that you can have things pay garnished. There are tools available that can be tailored to individual circumstances to trigger compliance, and Parliament doesn't have that. It's also really important to know, and just to be clear about this, a specific committee or a specific MP does not have the power to trigger any of this. So if a committee says, we'd like you to come and speak to us, the person says, I'm not coming, they then issue a summons to compel you, try and compel you, you still say, I'm not coming. What the committee can do is refer that matter to the entire House of Commons. Then the House has to vote on whether they will actually take some enforcement action, call you to the bar, or whatever else it might involve. So there are some, I think, checks and balances in the sense that the entire House has to vote on this and actually make that decision. It's not something that can be done by just a subset of MPs through a committee.
So, okay. I'm sorry if I'm being sensational. I'm just a humble presenter. I just look at the microcosm of what we're talking about here, and I'm saying, okay, look, okay, I'm probably going to be summoned because, first of all, I've been doing a lot of writing on LinkedIn. I have the temerity of bringing you both of you here to address this issue when I guess parliamentarians of certain ilk do not want this to be publicized. That's fine. Now, you mentioned something about choosing to come. All right, now, why in the right mind would I want to come? If I use Tom Clark as an example, where they just lean into me, impugn my honesty, attack my wife's honesty, they'll probably even kick my dog for a moment because they just have nothing to do about it. Or as we did with Christian Firth, bring him to Parliament, stand behind the bar, and question him. Like I guess my recourse is, first of all, I would have to have you advise me, but like, do I have the ability to say, okay, listen, if you're going to grandstand for the TV, I'm going to grandstand for the TV, and if you want this, I will pull an Al Pacino and say, you're out of order, type of thing. Like at the end of the day, like, why would you in your right mind go to one of these things? And is it as bad as we said before? Like, could they come for you in the middle of the night and say, you must come with us, because you've been summoned by the comrade to be questioned in front of the whole parliament? And you say, wow, just because I made a comment about Polyev, this is why I'm going to be hauled in here. So let's address this one. How really, like, what is the real course of action for a normal citizen, forget public servant or politician, to like, hey, they call me to come in, I'm saying nah?
So yeah, let's zoom out, because I think it's easy to let the really sensational instances kind of give us the impression that that's always what it's like. But most of the time when a parliamentary committee is inviting witnesses, it's because they're studying a topic or policy or proposed law, and they want witnesses to give input in the policy process. So the witnesses come as subject matter experts. Let's say they're advocates for a certain group, or they have knowledge of the topic for whatever reason. They're there to help Parliament make good law and policy. Most witnesses, when they're invited, they really want to be there. They want to be invited. They want to give their input. They want to have their day on the Hill. They want to advance their policy. And that's great. That is democracy in action. That's most of the witnesses who appear. Some of the time, the committee focuses in on, and they're studying a topic like a government program, dealing with allegations maybe of mismanagement. So we think of the funding to the We Charity, the purchase of the Consul General's residence in New York, for example. Those types of studies that get a lot of play in the media. That's when things get heated. That's when you, as a witness, you may be in the hot seat. So the committee might ask a minister to come in, a head of a government department, civil servant, and really grill them on something. And sometimes they might even invite a member of the public. So we saw that for the contractor, for example, in the ArriveCAN issue, or a member of a board of directors or something, and put them in the hot seat. That's when the risks of coming to committee really start to manifest. And again, I have to say, it really depends on why they've asked you to appear, right? If it's for a policy input, the risks are much lower. But if you're being put in the hot seat like that, then yes, then it's time to really seriously consider the risk. So what jeopardy are you in if you are appearing in that committee? Do you have obligations, for example, not to disclose certain information? You think they're going to ask you a question, but you say, wait a minute, I have a legal obligation not to disclose information, or I have commercial interests or contractual duties not to talk about this or that thing. How am I going to deal with that? Am I being investigated for other things by another officer or by the police? And how sensitive is the information that I might give at this committee? Now, there is a certain immunity around when you show up to give your testimony. For example, you can't be sued for anything you say as a witness in Parliament, and your testimony can't be admitted against you in a criminal proceeding. But once it becomes public record, people know about it. And yes, it might have impacts on other things, investigations, for example. So you have to think about your legal interests and your legal jeopardy. And you also have to think about your reputation too. Even if there's no legal jeopardy, no wrongdoing at all, nothing to hide, even the questions themselves can put your reputation on the bubble. whether or not, before you even answer a single question. So that's a situation where, yes, you need to think carefully and maybe even get legal advice. But those are exceptional circumstances.
Alyssa?
I guess the one thing I would add, Andy, is you made the Al Pacino reference, and it is important to remember that the process in committee belongs to that committee. So a witness can't go in and say, no, I don't like how this is unfolding. Give me back my time. You will likely, a witness is typically given a chance to make an opening statement before the questioning proceeds. But once that questioning is underway, you're along for the ride. And witnesses need to be prepared for that. And I think a key part of that preparation, especially as Marion said, when it's a hot seat type of questioning, is to get really good advice before you go in.
Right. And we're getting close to the end. So I want to fast track to a comment that was made yesterday by the Speaker of the House, and where he implored members of Parliament to be better people, to do what's needed because the people are watching, type of thing. So where is all this going? Like, how does the recent conduct of the parliamentary committee people that I've mentioned, and in the cases that I've mentioned, influence the public perception of Parliament? When the Speaker is saying, guys and gals, why don't you be nicer, and let's be more gentle, and let's be more professional. Where's this all going in regards to committee, and then eventually to the House? And I'll let whoever wants to start go ahead.
I'll start. So from my perspective as a lawyer who advises clients who are about to appear at committee, I advise clients who are going to talk about a policy, and those who are, maybe going to be in the hot seat. But even witnesses who are going to just talk about policy now, there's still now this risk. If the committee becomes interested in you for another reason or thinks you're being evasive, yes, they can push. And sometimes when you think through that, sometimes it's just too risky, and people might decide to turn down that invitation to appear before the committee because they're worried about, what might happen in the course of events. So instead of focusing and advancing the policy and participating in the democratic process, you're worried about risks. And I think that puts a chill on democratic participation. And I think that's a real shame for our democracy.
And if I could just build off that. So I agree with everything that Marion just said. I also think there's a broader issue about the legitimacy of our democratic institutions in the eyes of the public, the people it's intended to serve, right? So, as a theme you'll have heard running through my comments is just how old this system is. And that gives us both a really rich democratic heritage, but sometimes it also gives us rules and institutions that don't or haven't evolved to keep up with the times. So we now live in a legal context where individuals have rights, and you're entitled to a fair process when you're involved in something that could affect your rights. And Parliament and its processes have not kept pace with that. And I think as we see the gap between how witnesses are treated in committee, for example, and grow with how a witness would be treated in a courtroom, for example, I think there's a real risk that the legitimacy of that kind of questioning will be raised more and more, and could actually influence the way the law evolves. Right now, the courts have repeatedly said, we have a rich body of case law that says Parliament, once it's parliamentary privilege, only Parliament gets to decide how that's going to work, what the rules are, what's offside, what's not. That could change. That's not written in stone going forward. Until that happens, I mean, that's a slow process. That's the long-term vision of where things might go. Until that happens, I think individuals need to think really carefully about how they're going to interact with our parliamentary institutions when they're asked to appear as witnesses.
Marion Sandilands, Alyssa Holland, thank you so much for being with us on the show. Stay right here. We're going to be right back to you in just a moment. If you enjoyed what you hear today, this is the beginning of season 2, where we're going to go deep into the education of Parliament and try to get us to understand more about what is going on in Parliament Hill and how it's affecting us, not only here in the riding, but elsewhere around the world. And if you have any comments or concerns or any questions that you'd like to pose to our guests, feel free to contact us here at Addressing the Issues at Rogers TV Brantford 20.